questions coming in. If we could turn to each of you, both John and Michael, feel free to speak to these questions. But I want to kind of go back to when we were talking about the damages and permanent injunctions. Can a trade secret plaintiff obtain damages and a permanent injunction? Our attendee wanting to know if you could clarify a little bit more, drill down a little bit more on that. John, we'll start with you, and then Michael, if you have thoughts.
Yeah, sure. Well, here's the thing: if damages are what your out of pocket has been, and you don't want to suffer any more damages, then those two things aren't mutually exclusive. So you're likely to be able to get both. On the other hand, if your damages are based on what's going to continue to occur with respect to use of the trade secret, like a royalty, it makes no sense that you have an injunction, because you can't get damages based on future use and at the same time get an injunction. So it really depends on the first part, which is, am I being compensated for what I've lost already, as opposed to, am I being compensated for damages that I might continue to incur?
Excellent. Michael, thoughts from you before we move on?
I agree with that analysis completely. The key is, obviously all these cases are extremely fact dependent, and the issue is, do the remedies duplicate or overlap and result in a double remedy? So if you can separate out what the damages are covering versus what the injunction is trying to achieve, there's no reason why you cannot have both forms of relief. For instance, damages may be recoverable for harm that was suffered by the plaintiff prior to the injunction being entered, and then the injunction prevents any harm from occurring in the future. And if that injunction is entered, obviously any further harm would not be recoverable or actionable in the form of damages.
Excellent. Thank you so much. A question here now about DTSA. Can a trade secret plaintiff obtain in the same suit one form of damages under the DTSA and another form of damages under state law? John, you want to start with that one, and then we'll move to Michael?
Sure. The federal statute expressly does not preempt state law. So the starting point is that you could recover under state law what you, for the sake of discussion, might not be able to recover under federal law. But that's not the end of the inquiry, because there's another step. Many state statutes are considered to preempt other kinds of recovery, right? So what happens then is you have to look to the state statute and see if under that state law your recovery is limited. But as between state and federal, federal does not preempt state. The one thing, though, is that you can't have a double recovery. So you can't get, hey, I'm out $5 under the federal statute and I'm out $5 under the state statute, so I get a total of 10. No, if you're only out $5 for that injury, you only get $5. But there may be other kinds of relief available under one statute that's not under the other. And since the federal doesn't preempt the state, if it's available under the state, you may be able to recover under both. You can certainly assert both in the same case.
Excellent. Michael, thoughts from you?
I actually have a question for John, specific to the New York's position regarding avoidance damages. And I don't know if there's any, if he has any ideas on this, but in a trade secret action brought in New York, where you have both a claim under New York law and a Defend Trade Secrets Act federal claim, could you use federal law to argue that that the plaintiff is entitled to avoidance damage, cost avoidance damages under federal law that might not be available under New York law? Would a New York court not allow that?
Well, that's an incredibly insightful question, because we're still trying to figure that out as these things get litigated. Typically, a federal court is informed, to use a kind of loosey-goosey word, informed by state law. So there are some federal judges that will say, well, I'm just not going to do that because it's not allowed under state law. But they are two separate statutes. The best way I can explain it is that state law will inform federal law, but federal law will rarely inform state law. So if it is not available if it's available under state law, a federal judge might allow it pursuant to the federal statute. But if it's available under federal law but not under state law, it's going to be harder to get because they are been looking to accommodate the forum state when they decide the scope of the remedies. And it's one of the reasons why this is such an art and not a science, because we don't know until there is a larger body of case law as to how courts are going to look at this. And that's why that Brooks decision is such a landmark decision, because it raises a lot of red flags about what might happen in the future. It's an excellent question.
Excellent. Thank you so much, each of you. I have another question coming in here. And again, if we could just sort of clarify for, and because I know we've talked about the difference between the state law and the federal law, and we've talked a little bit about the royalties, but, and, you know, if we have that injunction, but could a litigant obtain in the same suit damages under trade secret law and another cause of action?
I'll take a stab at that. And the short answer is yes, but again, with the caveat that generally a court will not award duplicative damages for the same harm. And quite often there may be overlapping causes of action that may have different legal theories, but are really trying to protect against the same harm. So therefore, you know, there may not be a recovery under two separate theories. An example of, you know, that we talked about earlier of a case where a court did allow and a jury did award damages under two separate theories is the Texas case, the Title Source versus House Canary case that I talked about earlier. In that case, the damage award consisted both of actual and punitive damages for the trade secret misappropriation, as well as actual and punitive damages for alleged fraud. The fraud allegation was based upon misrepresentations that House Canary claimed that Title Source made in inducing House Canary to turn over its confidential and proprietary information. Now, I have to say it'll be interesting to see whether what the court does, ultimately the appellate court does with that decision on appeal, because from my reading of the case and the background, it does seem like those damages may be somewhat duplicative, because you're talking about damage for the same type of harm. But right now we're still just looking at a jury verdict that the trial court did uphold the verdict, but it remains to be seen what the appellate court does with that.
Yeah, it's interesting. Yeah, oh, thanks. It's interesting because, as I mentioned before, you know, the federal statute doesn't preempt the state law statute, but many state law statutes have preemption effect. And here's what I mean. In New Jersey, which adopted a form of the Uniform Trade Secret Statute, the Uniform State Statute, a court has expressly held that the statute does not preempt other causes of action. So where they're not preempted, often you will see the theft of trade secret claim being pled in the same complaint that also has a tortious interference claim. Because someone will argue, well, you're tortiously interfering with my business and by stealing my trade secret, right? Or they might file that claim against the party that hired the employee that left your employ. And so they'll be in the same case. On the other hand, there are other states who have adopted their own form of the uniform statute, and they say, no, if it involves a trade secret, the only recovery you can get is under state trade secret law. So it's this kind of two-level analysis. The first is whether there's preemption between state and federal, and the vast majority of the time, the federal statute doesn't preempt the state law statute. But the next level of inquiry is, well, does the state law preempt other causes of action that are based on the same facts? And there are many states that say, no, you can't sue. We have trade secret law. You sue under the trade secret statute if that's what's in play, and they don't allow other claims. So you just really have to be very aware of the law that applies.
Excellent. Thank you so much. We have just a limited amount of time, but a question now coming in from one of our attendees, a bit of a hypothetical scenario. I'm going to try to see if we can get either of you to either give the resource or give your thoughts on this. So the example is a former management employee. So somebody in management, a former employee, used trade secret knowledge of other subordinate employee performance, productivity, value to customers, etc., to sort of cherry pick away those employees to hire. Could the plaintiff recover any or all profit that that employer had generated through the services of these same employees who were hired away? So if we can kind of see that scenario play out in an example, that hypothetical former management has left, they're using their trade secret knowledge of their subordinate employees' performance, productivity, value. They're now hiring those employees away. Does the plaintiff recover any or all of that profit? Thoughts from either of you, John or Michael?
Yeah, I'll start, and then Mike, of course, jump in. Yeah, first of all, whoever asked the question should be a law professor, because that's a great hypothetical. I compliment the questioner on their example. And what's interesting about it is that there's a couple of parts to it. Like, one is implicitly whether that would be a trade secret, that particular information, the internal evaluations of the employee. And it could be, but it might not be. In other words, if the information was based on, in one context, I can envision how it, to me, definitely would be like, it's in performance reviews that are on paper, you know, not the whole world doesn't see that. In fact, the whole company doesn't even see it. And the other, which is less certain to be a trade secret, is, well, I worked with a guy and I thought he was really good. So let's assume that it is a trade secret. Then the next legal concept that's involved is something called causation, which we touched on very briefly, but to oversimplify an awful lot, the more attenuated the damage from the violation, the less likely you are to get damages. So to me, the legal issue is that without this particular information, I would not have been able to know which employees to hire. And there's going to be a lot of issues in there, like, well, are they employees at will, so they could leave any time? Doesn't matter. That would be one argument I might make if I was a defendant. Are they employees? And Mike has tremendous expertise in employment law. He'll tell you about employee contracts and things that may change the fact pattern. My overall answer, which is not the duck question, but is, yeah, maybe you could be. It's going to be very fact sensitive. It's a very interesting scenario. And I guess my practice tip would be to try to guard against it by having employment agreements or keeping your employment evaluations pretty confidential, so that you would have a right to seek this relief. Mike, what do you think?
Yeah, I think there's a big threshold question as to whether information regarding employee qualification, skills, performance, whether that would qualify as a trade secret, given its inherently subjective nature. And I think it'd be difficult for an employer to show that that sort of information is truly, number one, confidential and truly of tangible economic value, actual or potential. I have not, I've toyed with that idea in litigation. never have gotten a court to adopt the concept that that information regarding an employee's performance isn't of itself a trade secret. Now, assuming that you could identify specific information regarding an employee that is a trade secret, in terms of recoverable damages, I think you do run into a problem of, as far as trying to prove lost profits, of actually connecting lost profits or loss of business to the departure of the employee, because you run into hypothetical scenarios. So what makes this person so much better at his job than the person who would be in that position had the employee not been hired away? How do you prove that? Now, what I can tell you in litigating disputes like this, one sort of case that I've litigated that is very closely related and may be associated with this type of claim is a claim that a employee has breached a employee non-solicit provision in an employment agreement or a non-compete agreement, where an employee leaves and then they recruit others from their former employer to join them at the new employer. Typically, in recovering damages there, a court would not award damages for saying, okay, because this person was taken, that had a tangible impact on our profits. But what you can recover are things such as the cost of replacing the employee. If you had to go out to hire a headhunter, if you needed temporary labor, if you could show that it took the departure of the person resulted in somebody having to fill in that caused losses, that would all be recoverable. But actually tying, I haven't seen a case where I've seen the ability to tie the loss of an employee, him or herself, to evidence of actual lost profits or damages in terms of loss to the business beyond the costs associated with recruitment or replacement of the employee.